Incapacity is not just a medical issue, it is a legal one. Without the right documents in place, the court decides who gets to step in. It's called a guardianship or a conservatorship in this case. I'm going to explain what happens when no power of attorney is in place, why the families end up in court, and how to avoid that entirely. Hi, I'm Brian Minzy. I've been helping Missouri families for over 15 years. If you want to make sure that your family is protected and you have an estate plan and your future care decisions are secure, call us at Minzy Law Firm at 636-456-2345. Most people think incapacity only happens to an elderly person because they've got dementia or Alzheimer's, but that is very far from the truth. Accidents do happen. We've had many clients that have suffered traumatic brain injuries or the like, and when they do not have the proper documents in place, that's when you end up in the probate courts, because the judge will appoint that person to make those decisions for you. So what does incapacity actually mean? Incapacity means that you're no longer able to make decisions on your own. It means that you do not possess the requisite mental acuity such that you know what it is that you're doing and what your actions are going to result in. These consequences hit fast. You lose access to your bank accounts, you lose access to your investment accounts, and unfortunately the bills don't stop coming in. They still expect to be paid. And if you can't make the payments, that's where you end up in probate. The other thing too is that your house can't even be sold or your other assets liquidated without having somebody given the authority or the courts giving someone the authority. And here's the part that blindsides most families. It doesn't matter who's standing next to you. Your spouse, your adult children, your best friend. None of them have automatic legal authority to do stuff for you. Not unless you have given them the authority by having it in writing in advance. Without these documents, your family is locked out, and the only way back in is through the court system. So what happens when no one has legal authority to act? If you signed a durable power of attorney while you were healthy, the person you named takes over. They pay your bills, they manage your accounts, they handle your property, and they keep things running for you. It is seamless because you planned for it. But most people never get around to putting this plan into place. They assume their spouse is going to be able to handle things. They assume their kids are going to be able to handle things. And the reality then hits really hard. Banks and financial institutions draw a hard line. No power of attorney, no access. They won't make exceptions because your mortgage is due. They do not make exceptions because your spouse is standing there and begging for help. These rules exist to protect people from fraud, but in practice, it means everything in your name freezes while your family scrambles to figure out what to do next. When there's no power of attorney, the only option that is left is for someone in your family to file a petition to go to the courts and ask the probate judge for help. They have to ask for someone to be appointed as a conservator to manage your money and your assets. And in some cases, they'll appoint a guardian. The guardian is who makes personal and medical decisions. This process is anything but quick. A petition gets filed. The court assigns an attorney to represent you, the disabled person. Medical evaluations are ordered. Hearings are scheduled. Testimony is given. Judges need evidence before they can remove anyone's legal rights, because it is a constitutional right and they take it very serious. But all of that takes time. And while it drags on, your family cannot touch the assets. The mortgage goes unpaid, the phones go unpaid, the insurance goes unpaid. If a judge agrees that you're incapacitated, they'll appoint a conservator. That person has to post a bond in most cases, file a detailed inventory every single year on how they have managed and spent your money. They need to submit that to the court and then get the judge's approval on how it was spent. Every step involves paperwork, a court oversight, and ongoing cost until your death. If any family members disagree about who should be in charge, now it gets worse. Siblings argue, relatives second-guess the decisions. The court makes the final call. The court states what will happen. If no family member is suitable or willing, the courts will appoint a stranger. That person is called the public administrator, who will charge a fee that comes directly out of your estate to perform their duties. All of this happens because one document was never signed, never created. How different assets get locked down. One thing that surprises most people is that not all assets are treated the same when incapacity hits. The rules depend on how each asset is owned and what documents were in place beforehand. If a bank or investment account is in your name alone, it is completely locked. No one can write a check, make a withdrawal, or move a penny without either a power of attorney or a court-appointed conservator. Your bills keep coming in, but the money to pay them is untouchable. Real property, like real estate, your house, works in a similar way. If your home is in your name and nobody can sell it, refinance it, or take out a loan against it without your signature, once you're incapacitated, that signature is now impossible. So the house sits there. Even if the roof is leaking or property taxes are due, your family hands are tied until a conservator is appointed and given the legal authority to act on your behalf. Some families try to get around this by adding a child or relative's name as a joint owner on various accounts. This might solve the immediate access problem, but it creates new ones. Your joint owner's creditors could potentially come after those funds. So if you've added your child to that account and they file for bankruptcy, your money is going to be used. If they get divorced, your money ends up in their divorce proceeding. It is usually not a good idea to add anyone to an account that is not your spouse. Joint ownership is not a substitute for proper legal planning. It is a shortcut that will often backfire and cause other more serious catastrophic events to happen. Retirement accounts and life insurance policies are locked down too. No one can make withdrawals, roll over the funds, or even update the beneficiary designations without your authorization or a court order. And what is the court order again? It's the judge saying that it's okay to do it. And if the judge doesn't think it should be done, you're not going to be able to do it. Spouses are often shocked to learn that they can't access the retirement funds of their spouse during a crisis, and even when the money was meant to support them both. And also, the important thing to keep in mind is even a joint account in a husband and wife's name, the judge can order that money frozen and used only for the other spouse. They control that account as long as it has that disabled spouse's name on it. So what's the real cost to your family? When all of this comes together, the picture is painful. Your family is shut out of your finances at the exact moment when they need access the most. Mortgage payments get missed. Business decisions stall. Medical bills pile up with no way to actually pay those bills. And the court process itself becomes a burden. Attorney's fees, bond fees, filing fees, annual reporting and accounting requirements all add up fast. On top of that, conservatorship is a public proceeding. Your financial details become part of the public record for everybody to see. They'll know who your bills have to be paid to and for how much. They will know your family financial structure simply by walking into the courthouse and asking to see Fred Smith's file. But the worst part isn't the money. It's the stress. It's the conflict it creates with families during an already devastating time of their life. Siblings can fight over who should be in charge. Resentment building, relationships damaged. All of it is avoidable with a little bit of the time taken to create the right documents created and signed ahead of time. So how does the right plan change everything? Here's the good news. All of this can be prevented with proper planning. A durable power of attorney for financial matters allows the person you choose to step in immediately and manage your financial affairs without any court involvement. A healthcare power of attorney does the same thing for your medical decisions. These documents keep your family out of the courtroom and the people you trust you've put in control, at least until your death. If you take it a step further with a living trust, the protection is even stronger. It goes beyond death. When your assets are held in a properly funded trust, your chosen successor trustee takes over management the moment you are unable to. There is no court. There are no delays. There is no public proceedings. The trust document spells out exactly what is to happen with your assets and how they should be handled, who is in charge of those assets, and what your issues and wishes are. When you pair a trust with a power of attorney for finance and healthcare, and with that of a healthcare directive, you close virtually every gap that can cause your family stress and turmoil. Your family doesn't have to fight the system. They just follow the plan that you have already put into place. Without these documents, unfortunately, the state of Missouri will try to put a plan into place for you. But it does it through a court process that's slow, it's expensive, and very stressful for everyone involved. The difference comes down to one decision you make while you are healthy. Who controls what, when, and how when you cannot speak for yourself? If you do not have a power of attorney or any incapacity plan in place right now, please call us at 636-456-2345 for a free consultation. We will help you understand what your choices are and how the right choices and the right documents, when put into place, can protect you and your family no matter what happens. If you found this to be helpful, be sure to like and subscribe for more guidance on protecting your family and planning for the future.